Let's now go to Foreign Investment Act. Now, it's included in the syllabus provided by Justice Lionel. So, your FIA is Republic Act number 7042 as amended. So, here's the syllabus. Okay. In the case of Garcia versus Executive Secretary in 1991, Petitioner Garcia attempted to have FIA declared as unconstitutional. But in that 1991 case, the Supreme Court sustained the constitutionality of the law. Now, despite or notwithstanding the grounds propounded by Garcia that it is violative rather of the constitutional policy of developing a self-reliant and independent national economy effectively controlled by Filipinos and the protection of Filipino enterprises against unfair foreign competition and trade practices. The Supreme Court stressed that the petition is more of a question on the wisdom or efficacy of FIA. So that's why the Supreme Court sustained the constitutionality of the law. The policy of the law, principally to attract productive foreign investments, not only from foreign individuals, partnerships, and corporations, but similarly from foreign governments, including their political subdivisions. Another policy of the law is to encourage such investments to expand livelihood and employment opportunities for Filipinos. Also to enhance economic value of foreign products, to open up and expand access to foreign markets, and more importantly, the transfer of relevant technologies in agriculture, industry, and support services. At least by way of policy, these foreign investments are welcome as a supplement to Filipino capital and technology. By policy, the law says that there is no restriction on the extent of foreign ownership of export enterprises. Now, as regards domestic market enterprises, it may be up to 100%. Now, the only exception would be if the same would fall under the negative list. And these foreign-owned firms, in these domestic market enterprises, they are encouraged to undertake these certain measures to gradually increase Filipino participation in their respective businesses. So among of which is the taking in Filipino partners, electing Filipinos to their board, implementing transfer of technology, generating more employment for the economy, and enhancing skills of Filipino workers. For the definition of terms, we have foreign investment. So foreign investment means that any equity investment made by non-Philippine national in the form of foreign exchange or other assets actually transferred to the Philippines. And the requirement is that the same must be duly registered with the Bangko Sentral ng Pilipinas. For export enterprises, if the manufacturer, processor, or service enterprise exports 60% or more of its output, so it's either 60% or exceeding 60%, or a trader purchases products domestically and exports 60% or more of such purchases. So anything less than 60% might fall under domestic market enterprise. What is the rule as regards foreign investment in export enterprises? So foreign investment is allowed for as long as these products and services do not fall within either list A or B of the foreign investment negative list. No? So otherwise, foreign investment in export enterprises may be allowed up to 100% ownership. So the rule is that these non-Philippine nationals shall register with the Board of Investment and shall submit reports to ensure continuing compliance. The Board of Investment would have to advise the Securities and Exchange Commission or the Bureau of Trade Regulation and Consumer Protection or BTRCP of the Department of Trade and Industry. What would be the content of that advice? Any export enterprises that fail to meet the export ratio requirement. Take note that for an export enterprise, it must be at least 60%. So anything falling below 60%, that would have to be reported by BOI either to SEC or to BTRCP of DTI. And acting with that advice, SEC or BTRCP shall order the export enterprise to reduce the sales to domestic market to not more than 40% of its total production. So the remaining 60% shall be devoted to export enterprise activities. If there is any failure to comply with such directive, that would amount to cancellation by the SEC or BTRCP of the respective registration. And of course, together with imposition of some penalties. What is a domestic market enterprise? Any enterprise which produces goods for sale or renders services to the domestic market entirely, or as the IRR provides, or otherwise engages in any business in the Philippines. So if exporting a portion of its output fails to consistently export at least 60% thereof. So if it is exporting 60% or more, then it shall qualify as an export enterprise. Anything less than that, SEC or BTRCP may make the proper action to reduce their sale to domestic market only up to 40%. I'm referring to export enterprises. Otherwise, if it will keep on breaching the export below 60%, it shall be subject to proper actions by SEC or BTRC. Foreign investment in domestic market enterprises. Non-Philippine nationals may own up to 100% of domestic market enterprises, unless there is a prohibition under the Constitution or the same falls under the foreign investment negative list. What is doing business in the Philippines? In a past bar examination, what had been asked is rather what constitute not doing business. But let's first discuss the acts constituting doing business in the Philippines. In Cargill versus Intrastrata 2010 case, the Supreme Court mentioned that the definition of doing business as well as not doing business are effectively provided for, defined under the FIA. However, by way or by means of enumerating only the acts or activities which shall be deemed to constitute either doing business or not doing business. So what are these acts that constitute doing business? So the soliciting orders, opening offices, No? So, another one is if in any calendar year there is a stay in the country for a period of or periods totaling to 180 days or more. No? So at least half a year of stay in the country. Participation in the management, supervision, or control that constitute doing business. And more importantly, this more comprehensive enumeration, no? Wherein it implies a continuity of commercial dealings or arrangements. No? Any activities done by a foreign entity or foreign corporation that implies continuity of commercial dealings or arrangements will be considered as doing business in the Philippines. Again, in Cargill, citing Antam Consolidated, no, wherein the case filed by the foreign entity is predicated on failure to deliver coconut crude oil, the Supreme Court emphasized that important element of continuity of commercial activities. No? What happened in that case in Antam, the contract between the foreign entity and NMC, the contracts were amended for 3 times. No? So that the amendment for 3 times was being advanced as indicative of doing business in the Philippines. However, the Supreme Court said the amendment of those contracts was or were merely done to give a chance to the NMC to deliver to the foreign entity the molasses subject matter of their contract. No? And in that regard, the action or rather the failure to deliver the coconut crude oil led the foreign entity to file the particular action. No? So in that respect, the Supreme Court said it does not or it did not signify the intent of the foreign entity to establish a continuous business or extend its operations in the Philippines, because the primary reason for the action is simply to collect out of that contract. While there were amendments on the contract, those amendments were made simply to give the local counterpart the opportunity to make good on his bargain under the contract. What then are the acts that constitute not doing business in the Philippines? If it is merely an investment as a shareholder, it will not constitute doing business. Having a nominee director or officer, also not doing business. The appointment of a representative or distributor by itself will not constitute doing business in the Philippines. And of course, publication of a general advertisement. Maintaining of stock of goods in the country but to be processed by another entity in the Philippines, is also not doing business. Okay? Consignment by a foreign entity of equipment for export, collection of information in the country, it is not doing business in the Philippines. Or performing services auxiliary to an existing isolated contract but not on a continuing basis, that won't constitute doing business in the Philippines. In Cargill, the Supreme Court stressed, citing National Sugar Trading Corp., that activities within Philippine jurisdiction that do not create earnings or profits to the foreign corporation does not constitute doing business in the Philippines. So, if that's the case, there is no justification to require upon the foreign entity to secure a license for the purpose. How about the appointment of agent or distributor? Now, so we said by itself or in itself, the appointment of an agent or distributor will not constitute doing business in the Philippines. No? In the case of Han versus Court of Appeals involving BMW, the Supreme Court said if Han is an agent or distributor in the Philippines of BMW, then BMW may be considered doing business in the Philippines, and the trial court acquired jurisdiction over BMW by virtue of the service of summons on the DTI. Now, so sweepingly, you cannot just say that if a foreign entity has appointed an agent or distributor, it may already be deemed as doing business in the Philippines. Note that the Supreme Court also stressed that if Han is not the agent of BMW but an independent dealer, then BMW shall not be considered as doing business in the Philippines, because if merely an agent or distributor in the concept of an independent dealer, that will not constitute doing business. So it's really more on the control being exerted by the foreign entity upon its own agent or distributor in the Philippines. So at least you would know the meaning of the acronym BMW. In Steelcase versus Design International, the Supreme Court made it very clear that the appointment of a distributor in the Philippines by itself does not constitute doing business. Now, the qualifier is that if that appointment of distributor is under the full control of the foreign corporation, then that will now be deemed as doing business in the Philippines. So an independent entity which buys and distributes products other than those of the foreign corporation for its own name and its own account is an indication that that foreign entity is not doing business in the Philippines, because the distributor or the agent of the foreign entity is rather an independent entity. But if as a distributor or agent, it falls under the full control of the foreign entity, then the foreign entity shall be considered as doing business in the Philippines. Mere ownership of a property, in itself, it will not constitute doing business in the Philippines. In MR Holdings versus Bahar, the Supreme Court held that if mere ownership of a property is not accompanied by its active use in furtherance of the business for which the foreign entity was formed, then it will not constitute doing business in the Philippines. Because in that case, MR Holdings was simply constituted as an assignee of the mining properties, facilities, and equipment. How about mere exportation of goods? Now, the Supreme Court held that mere exportation of goods will not by itself constitute doing business. However, if exportation of goods would be accompanied by any specific commercial act within the territory of the importing country, then that will already qualify as doing business in the Philippines. So therefore, if it's merely exportation of goods but without doing any commercial activity in the territory of the importing country, then it shall not be considered as doing business in the Philippines. In Agilent Technologies, the Supreme Court mentioned this important case of Mary Lynch. Now, within the Supreme Court held that if for 7 years, no, spouses Lara, the respondents therein, engage in futures contracts with the foreign entity Mary Lynch, surely that should be considered as doing business in the Philippines. Likewise, in the case of Japan Airlines, no? While Japan Airlines or any aircraft of Japan Airlines has never landed in the Philippines, but it sold tickets in the Philippines through a general sales agent and even opened a promotions office here, the Supreme Court said that that should be considered as doing business in the Philippines. Why? Because commercial dealings of JAL in the Philippines were continuous. Now, so that would constitute doing business in the Philippines. Also, in the case of General Corp of the Philippines versus Union Insurance, while it had already appointed a settling agent in the Philippines, but there were 12 marine insurance policies that had been issued, then that already indicates continuity of commercial activities in the Philippines, and therefore should be deemed to be doing business in the Philippines. No? Note also this case of Eric's PTE Limited versus Court of Appeals and Enriquez. Now, wherein the foreign corporation sold its products to a Filipino buyer who ordered the goods 16 times within an 8-month period. No? So, in that case, the Supreme Court said that clearly established continuous business of Eric's in the Philippines, and therefore should be deemed to be doing business in the Philippines. So, in determining whether a foreign entity is doing business in the Philippines, you have to check if there exists a clear intention on its part to continue the body of its business in the Philippines, no? Regardless of the span or period of time involved. So what is overriding rather is the demonstration of clear intention. In communication materials, no, likewise in Top Weld case, no, these two cases are very important cases. No? The Supreme Court stressed that in those contracts involved in communication materials and Top Weld, no, there is that highly restrictive nature of certain provisions in the agreements, no, to the effect that the Philippine entity is reduced to a mere extension or instrument of the foreign corporation. No, if that happens or if that is present, the Supreme Court held, then the Philippine entity shall be considered to be under the full control of the foreign corporation, and therefore the foreign corporation or the foreign entity shall be deemed to be doing business in the Philippines. Now, just for instance, when there is that no competing product provision. No? So meaning the Philippine entity as a mere extension of the foreign corporation may not deal with any other product. Now, very much unlike if the Philippine entity is appointed as an agent or distributor, as an independent dealer, and therefore may engage to market, offer to sell, or sell other products in the country, then in that instance, the foreign entity no, may not be deemed to be doing business in the Philippines. What is this twin characterization test? No? As early as 1941, no? In the ponencia of Justice Laurel, the Mentolatum case. In that case, you will not see, of course, direct reference to the test as twin characterization. No? But the test provided by the Supreme Court tells us that there are two characteristics that must be present in an activity for it to be considered as doing business in the Philippines. No? The Supreme Court in that 1941 case ruled that if the foreign corporation is continuing the body or substance of the business or enterprise for which it was organized, or whether it has substantially retired from it and turned it over to another, no, then that is an indication that the foreign entity is doing business or engaging in or transacting business in the Philippines. No? Another aspect of the test is the second characteristic. No? If there is continuity of commercial dealings and arrangements, and therefore would contemplate performance of acts or exercise of some of the functions normally incident to and in progressive prosecution of the purpose of the organization. No? So these two characteristics must coexist. No? Continuing the body or substance of the business or enterprise and continuity of commercial dealings and arrangements in the Philippines. No? So under the Mentolatum case, no, referring to it as the twin characterization test, then the foreign entity is deemed to be doing business in the Philippines. In the 2004 case of Agilent Technologies, the Supreme Court now gave precise name to the test. No? We refer to as twin characterization test. The first aspect is referred to as the substance test, while the second element or characteristic is referred to as continuity test. So if there is continuing, no, of the body of the business or enterprise for which it was organized, no, or it has substantially retired from it and turned it over to another, at least in the Philippines, then that would meet the substance test. And the second test is continuity test. Now, if there is continuity of commercial dealings and arrangements in the Philippines. No? So, under this twin characterization test, you have the substance test and the continuity test. How about in a case of online gaming? In the case of online gaming, no? So this foreign entity proposed to provide an online platform in the country that will offer various content and services such as an online community and an online gaming system. The online platform is an internet-based system and will allow persons located in the country to create an account in order to participate in the online community and to purchase content from and or use the online platform services. The foreign corporation will have no physical presence in the Philippines. Its servers are located outside the Philippines. In addition to offering and selling online platform services in the Philippines, this entity will also accept online payments using the online platform in any currency, marketing or advertising the online platform in the country, hiring independent contractors for marketing or advertising of its products, and selling of the prepaid cards for its online gaming services. No? So the question is that online gaming, no, may it be considered as doing business in the Philippines? So out of those facts, we may apply the twin characterization test. No? Does it meet the substance test? Does it meet the continuity test? No? Along the application of the twin characterization test, no? This case being or forming parts of the facts presented with the Securities and Exchange Commission, no? The SEC opined that under the twin characterization test, be it under substance or continuity test, it would appear that online gaming, no, under this set of facts would constitute doing business in the Philippines. Now, but as we have said, the twin characterization test, no, was first discussed in 1941, no, in Mentolatum case, no, and for sure that case did not consider the situation involving an internet-based online platform that is present in online gaming. No? So, what has been applied by the Securities and Exchange Commission, particularly the Office of the General Counsel, no? In its opinion rendered in 2017, is the application of the so-called sliding scale test. According to the SEC, the foreign corporation would have minimum contacts with the Philippines. Now, the online platform cannot be considered as a passive website, quote-unquote, considering that there will be sufficient contacts with the account users in the Philippines. And such platform is not used to merely post information. No? So it tells you that if it merely posts information, then that should be considered as a passive website. The online platform should be considered rather as an active website, quote-unquote, which generates sufficient contacts and business over the internet. Now, so in that respect, the SEC opined that in that online gaming, the same shall be considered as an active website. And therefore, in an active website, there would be established minimum contacts with the Philippines, and therefore would make the foreign entity, as far as that proposed business activity is concerned, to fall within the personal jurisdiction of the Philippines. And in that end, should be considered to be doing business in the Philippines. So, in that opinion, what we can appreciate is that if the platform is considered as an active website, there being sufficient contacts and business over the internet, that may be considered as doing business in the Philippines, compared to a passive website wherein the main objective is only to post information. So what then is that sliding scale test? So you have passive website, you have active website. No? But as it is now, you do not just have a passive website and an active website. No? There would be what is referred to as an interactive website. No? So, uh, in between the passive and the active, you would have the interactive. No? So, in a sliding scale test, if the activities being contemplated or being done by a foreign entity in the local jurisdiction, particularly in the Philippines, no, would be would lean more to passive websites, then it may be said to be not engaged in business in the Philippines. However, if the activities of the foreign entity being interactive would lean more to an active website or active websites, then it would generate sufficient business over the internet and therefore would be indicative of doing business in the Philippines. No? So that's why they call it the sliding scale test, because what is being considered in the test is the likelihood that personal jurisdiction can be constitutionally exercised as being directly proportionate to the nature and quantity of commercial activity that an entity conducts over the internet. No? So an interactive website falls in the center of the scale, since they are hybrid sites that contain elements of both passive and active websites. No? So if it is interactive, the courts are given the free hand to determine whether to exercise personal jurisdiction. No? To check on a case-to-case basis whether that interactive website leans more to passive websites or rather to active websites. And in case of the latter, meaning leaning more to active websites, then by sliding scale test, it shall be considered to be engaged in or transacting business in the Philippines. No? So in the SEC opinion, by applying the sliding scale test, that online gaming is deemed to be doing business in the Philippines. Take note, however, that that SEC opinion is rather based principally in that case of SIPO Manufacturing versus SIPO.com case, no? A foreign ruling, no? That was relied on or coined in way back in 1997. No? In the country, it was applied only in 2017. No? If you would bother to check the materials regarding the SIPO manufacturing case or the so-called sliding scale test, there is a growing belief, no, or position against the application of the sliding scale test. Why? Because even if or given the complicated set of facts, no, particularly online gaming or any online activity which by itself is complicated, no? Under the sliding scale test, you are just given the simple solution. No? Meaning, you just have to determine, is it a passive website? Is it an active website? Or is it an interactive website, being a hybrid of passive or active? And simplistically, you just have to check, does it lean more to passive or does it lean more to active? If in the latter, then the local court can exercise personal jurisdiction to the extent that the foreign entity may be considered to be doing business in the local jurisdiction. No? So, with that, some authorities against the application of sliding scale test puts more, shall we say, critics or criticism against that exercise of unbridled discretion upon courts to make the determination whether to exercise personal jurisdiction over the interactive website on a case-to-case basis. So, but at least in this jurisdiction, we have that SEC opinion which tells us that under the facts given in an online gaming being considered to be an active website or involving active websites, the same shall be deemed to be doing business in the Philippines. The right to sue. So in MR Holdings, the Supreme Court listed down three scenarios regarding right to sue involving a foreign entity. And they are stated in this wise. If a foreign corporation does business in the Philippines without a license, it cannot sue before the Philippine courts. If a foreign corporation is not doing business in the Philippines, it needs no license to sue before Philippine courts on an isolated transaction or on a cause of action entirely independent of any business transaction. And if a foreign corporation does business in the Philippines with a required license, it can therefore sue before Philippine courts. So, as correctly stated, in that case, it is not the absence of the prescribed license to do business, but rather the doing of business in the Philippines. So, if a foreign entity will do business in the Philippines, then it must secure license to do business. But you have to take note, of course, for a foreign corporation to be considered as such in this jurisdiction, it does not suffice that it is incorporated pursuant to laws other than those of the Philippines. There must always be observance of the rule on reciprocity, meaning that same right or privilege must be extended by the foreign jurisdiction to Filipino citizens in that country. What is the doctrine of pari delicto? So that is enunciated by the Supreme Court in the 1985 case of Top Weld Manufacturing. So in that case, so between the local entity and the foreign entity, this local entity was able to have several transactions with the foreign entity. The thing is that, of course, this foreign entity was not licensed to do business in the Philippines. But notwithstanding the absence of a license to do business, the local counterpart transacted with a foreign entity. So given those circumstances, the Supreme Court considered both the local entity and the foreign entity in pari delicto. And therefore, being in pari delicto, the Supreme Court held that no remedy could be afforded to the parties because of their presumptive knowledge that the transaction was tainted with illegality. Because according to the Supreme Court, equity cannot lend its aid to the enforcement of an alleged right claimed by virtue of an agreement entered into in contravention of the law. So in Top Weld Manufacturing, we have the doctrine of pari delicto. And in case of in pari delicto, the court will simply leave the parties where they are. No remedy, no uh, uh, no remedies, no court action may be availed of by any of the parties in pari delicto. So that is the top world doctrine in 1985. In 1992, the Supreme Court has the occasion to rule in Merrill Lynch Futures versus Court of Appeals. No? And what the Supreme Court applied in that case is rather the doctrine of estoppel. No? And estoppel, as we know, is also an equity sanction, or rather is a remedy sanctioned by equity. So under the doctrine of estoppel, the other party cannot deny the corporate existence of foreign entity without a license. So if it does not have a license to do business in the Philippines, but if transaction is had with a foreign entity, then both parties shall be considered to be in estoppel. Or with respect to that party questioning the corporate existence of the other, he shall be considered to be under the doctrine of estoppel. No? But under the doctrine of estoppel, the Supreme Court made it clear that it applies to foreign as well as to domestic corporation. No? So if a party would raise the issue of corporate existence, by doctrine of estoppel, they are stopped. They are prevented from questioning the corporate existence. Why? On the premise that, especially if that person questioning the corporate existence has already received the benefits of the contract. So in that Merrill Lynch Futures case, for several years, these spouses Laras were able to receive benefits out of the contract with Merrill Lynch Futures, which in that case, a foreign entity that does not have license to do business in the Philippines. But the Supreme Court, applying the doctrine of estoppel, applying it against the Laras, the Supreme Court said they are stopped from impugning the capacity to sue of Merrill Lynch Futures. So you have the doctrine of pari delicto versus the doctrine of estoppel. In 1997, in the ponencia of Justice Panganiban, if I'm not mistaken, in that other important case of Eric's PTE, the Supreme Court reiterated the rule: no license, no access to courts. So instead, the Supreme Court applied the doctrine of pari delicto, because the Supreme Court did not allow the foreign entity any access to local courts on the premise, or on the ground rather, that it does not have license to do business. So the case was rather dismissed, or the dismissal for lack of capacity to sue was confirmed by the Supreme Court. So in that case, the Supreme Court said, if the foreign entity is doing business in the Philippines without license, it shall not be given the right to sue or any access to the courts. But what is rather clear in that case is that because the complaint of the foreign entity of Eric's PTE Limited was dismissed merely on technical ground. That is, lack of capacity to sue. So therefore, there would be no res judicata. So the Supreme Court said, Eric's PT Limited or any foreign entity without license to do business can very well apply for a license to do business. And by securing a license, that foreign entity would be giving assurance that it will abide by the decisions of the local courts. And any license subsequently acquired will cure the lack of capacity at the time of the execution of the contract. No? So effectively, the Supreme Court said, we will first dismiss your case, your petition and your case for lack of capacity to sue. But as soon as you secure the license to do business, no, then your lack of capacity will be cured at the time of the execution of the contract, and therefore you can now have access to Philippine courts. The rule on registration of investments of non-Philippine nationals. So to repeat, non-Philippine nationals may do business or invest in domestic enterprise up to 100% of its capital. No, the exception would be as to domestic market enterprise except in areas under the negative list. In export enterprises, no, also except in areas falling either under List A or List B. This rule allowing doing business or investment in domestic enterprise, be it domestic market enterprise or export enterprise, is subject to the rule on reciprocity. The law says that the country or state of the applicant must also allow Filipino citizens and corporations to do business therein. No? So it reinforces the rule in the old corporation code and now under the revised corporation code that a foreign entity may be considered a foreign corporation but always subject to the rule on reciprocity, because only a foreign corporation in this jurisdiction will be issued a license to do business. Now, to repeat, a foreign entity incorporated pursuant to laws other than those of the Philippines is not automatically a foreign corporation in this jurisdiction. Now, it is nothing but a foreign entity. It must be subject to the rule on reciprocity, meaning the country of incorporation must also allow Philippine citizens and or rather Filipino corporations as foreign corporations there, and therefore being foreign corporations, they may now be allowed to apply for a license to do business. A non-Philippine nationals qualified to do business, but if it will engage in more than one investment area and one or more of which is in the negative list, it may still be registered. Now, however, it will not be allowed to engage in the investment areas which falls under the negative list. Now, the same with existing enterprises. Now, they may be allowed to increase the percentage share of foreign equity. Now, for as long as it will not fall under the negative list. Even in the transfer of ownership from one foreign company to another, it will be allowed, no, even if the enterprise is engaged in an area in the negative list, for as long as there is no increase in the percentage share of foreign equity. Okay. How do you do the application for registration? No? If it's a foreign corporation or domestic corporations or partnerships which are non-Philippine nationals, no? So with the Securities and Exchange Commission. With respect to single proprietorships in Metro Manila, then with the BTRCP or the DTI National Capital Region. In the provinces, either in the extension offices of the SEC for corporations or partnerships, and for the provincial and for sole proprietorships with the provincial offices of the DTI. If enterprises seeking to remit foreign exchange abroad, no, for purposes of remittance of profits and dividends and capital repatriation in connection with the foreign investment made, now they are deemed registered with the Bangko Sentral ng Pilipinas if they are properly registered, either with SEC or BTRCP. The negative list. No? What we have now is the 11th foreign investment negative list. It was issued by President Duterte on October 29, 2018 and became effective November 16, 2018. So of course, there are updates on the 10th negative list as to the scope and limitation of restrictions, which are rather more clarified. The recent changes in various laws on liberalization of foreign ownership, foreign investment, they are now incorporated in the 11 FINL. There would be a greater degree of certainty as regards applicability of foreign equity restrictions. And of course, the purpose is to attract foreign direct investments. Under the 11th FINL, you will see there the list of areas of economic activity whose foreign ownership is limited to a maximum of 40%. So it cannot go beyond 40%. Okay, and the FINL has two component lists. You have List A and List B. List A would cover the areas of activities reserved to Philippine nationals, no, by mandate of the Constitution and specific laws. On the other hand, List B contains the areas of activities and enterprises regulated pursuant to law. Under List B, you have either defense or law enforcement related activities or those activities having implications on public health and morals. For small and medium-sized domestic market enterprises, no, paid in equity capital of less than 200,000 US dollars or its equivalent, no, so reserved to Philippine nationals, no, because of that equity requirement, no. With respect, however, to such SMEs, no, for domestic market enterprises, if it involves advanced technology or it issues an undertaking to employ at least 50 direct employees, then they are allowed a minimum paid-in capital of 100,000 US dollars. For mass media and internet business, okay, the important change under the 11th FINL is with respect to mass media. Of course, Ownership and management of mass media shall be limited to Filipinos, no? Or corporations wholly owned and managed by Filipinos. No? Under the 11th FINL, the internet business is now open to foreign ownership. No? And that is based on DOJ Opinion Number 40, Series of 1998. No? So what you see here is that out of mass media, internet business is separated. No? And if it falls under internet business, it is now open to foreign ownership. For as long as an internet business, it only refers to internet access providers that merely serve as carriers for transmitting messages rather than being the creator of messages or information. Now, because mass media is involved in the creation of messages or information. Now, if it is simply involved in the transmission of messages, it shall only be considered as falling under internet business and therefore open to foreign ownership. According to DOJ, mass media involves transmittal, creation, publication, gathering, and distribution of news. On the other hand, internet business is limited only to offering to the owner of a computer the services of interconnecting to a network of computers, thereby giving him access to said services offered by the internet. No? So what is being considered is the factor of creation, no? Because it is negated in an internet business, no? Making it qualified to or for foreign investment. So foreign equity in internet business shall be limited to 40%. Now, in case an activity falls under or includes the so-called value-added services, no? Which means enhanced services beyond those ordinarily provided for by local exchange and inter-exchange operators. No? It may include messaging services, no? Audio and video conferencing, email services, information services, content and program services. Regarding practice of professions, foreigners are now allowed to teach in higher education levels. The qualifier is that except if the subject is taught in being taught in those included in a government licensure examination, like accountancy, medicine, and architecture. Regarding the complete list of professions that may be practiced by foreigners in the Philippines, their home countries shall allow Filipinos to be admitted to the practice of such professions. So also subject to the rule on reciprocity. Added to the list are pharmacy and forestry, which were previously restricted to Filipinos under the 10th FINL. So under the 11th FINL, foreigners may now engage in pharmacy and forestry. Practice of radiologic and X-ray technology, criminology, and of course law. They remain to be restricted to Filipinos. Marine deck officers and marine engine officers are additions to the restricted list under the 11th FINL. So to preserve these positions, marine deck officers and marine engine officers only to Filipinos. With respect to private security agencies, the absolute foreign restriction has rather been expanded. It now includes organization and operation of private detective, watchmen, or security guard agencies. For corporate practice, no? So you can also check the negative list for the list of uh, practice or professions that may be practiced by a corporation. No? So in the areas of corporate practice that may be allowed to foreigners, no, they now include aeronautical engineering, biosystems engineering, forestry, and social work. Subject to the requirements and conditions under the pertinent professional regulatory law. With respect to locally funded public works, foreign equity may be up to 40%. But if that would involve construction of defense-related structures, limited only to 25%. Full foreign participation with respect to educational institutions for foreign diplomatic personnel and their dependents and other foreign temporary residents. Also, full foreign participation in lending companies, financing, and investment houses being regulated by the Securities and Exchange Commission. How about with respect to former natural-born Filipinos? No? So they have the same investment rights of Philippine citizens under the following laws. No? Under the IRR, they expressly included activities listed under List B, including defense-related activities. However, subject to that requirement, if specifically authorized by the Secretary of National Defense. Okay. However, those rights shall not extend to activities reserved by the Constitution, including the exercise of profession, no, defense-related activities, if without a specific authorization from the Secretary of National Defense, and such other activities. A former natural-born Filipino may be a transferee, no, of a private land, but subject to this maximum area, 5,000 square meters for urban land, 3 hectares for rural land. No? So, where both spouses are qualified, one of them may avail of the privilege, no, but shall not exceed the allowable maximum area. So, for 2 lots, the same rule applies. No? They shall not exceed the maximum areas allowed. Any private land acquired by a former natural-born Filipino, the rule is that the same shall be primarily, directly, and actually used by the transferee in the performance or conduct of his business or commercial activities. So, whatever business a former natural-born Filipino may want to have or to do is allowed by law to be done with respect to those private lands. Now, the qualification of every is that they may not engage in activities that are not that are rather included in the negative list.